And we are live. Hello, everybody, and welcome to Lorenzo Family Law. So this is going to be part one of my live stream where I go through and try to create a document that I will be submitting for my motion upcoming this week, next week, in the Ontario family law system. So as I mentioned last time, step one will be to create a power of attorney. So I have a general idea of what a power of attorney is. Let's go through and read and see if a power of attorney is in fact the correct process for me to follow, and how to create one. So I started here on the Attorney General Ontario website. Okay, so it seems like a good place to start, given that I'll be in the Ontario court virtually from La Belle Province of Quebec. You know, I'm sure they're still going to claim jurisdiction over me, or attempt to claim jurisdiction over me, because I am their chattel, you know, and they licensed me. But let's try to get out of it. So, step number one, let's read through to see how a power of attorney works. So a power of attorney is a legal document in which you give someone you trust, called your quote-unquote attorney, the right to make decisions for you if something happens and you are no longer able to look after matters on your own. There are two types of power of attorneys: a power of attorney for personal care and a power of attorney for property. So I don't think I care about personal care. I don't need somebody to make decisions about my health care or my housing or other aspects of my personal life, such as meals and clothing. Although that would be nice, you know, if I become mentally incapable. So what I'm after here is, because what the family law system actually is a system for property. And they believe that they have the right to my property. And I'm not sure why they believe they have this right to the fruits of my labor, to the fruits of my sweat and tears. So what I want to do is create a power of attorney for my property. And so a power of attorney for property does the following. The person you name can make decisions about your financial affairs, including paying your bills, collecting money owed to you, maintaining or selling your house, or managing your investments. So this is what I want, right? I want to remove the ability of the family law court to administer my property, which is, in my opinion, without right, and give that power back to me. So right now, my person should be making decisions, but apparently my person is incapable. I went to court as a man and they ignored me, and they continued to administer my person's property without right. So I will be creating a power of attorney for my person's property. And if you don't understand all the phrases that I'm saying, what exactly a person is, I suggest you look it up. But I do plan at some point to discuss these in further detail. Although there are a lot of resources out there, which is where I've learned a lot of this from. So the information is not hidden, you know, it's just made very difficult to understand. Okay, so you don't have to create a power of attorney, the Attorney General tells us. But if something happens to you and you don't have one, other arrangements will have to be made. So this is what's happening to me right now in family court. Arrangements are being made on my behalf by some administrator. So a family member may have the right to make certain personal care decisions and apply to become the guardian of your property. Alternatively, someone else, like a close friend, could apply to the court to be authorized to act for you. So that's what I want. I want to apply to the court to be authorized to act for my person. If no suitable person is available, the government may have to step in, which I think is what they did, right? So they declared somehow that no suitable person is available to administer my property, and so they declared that these people, the office of the public guardian and trustee, which is part of Ontario's Minister of Attorney General. And who are these guys? Is committed to improving the accessibility of our clients with disabilities. Protecting the mentally incapable people. So that's who we are, guys. Protecting the public's interest in charities, searching for heirs for estates, investing perpetual care funds, dealing with dissolved corporations. We may even be considered a dissolved corporation. Who knows, right? Like it's hidden in all this legalese garbage. Okay, so I believe that there's no suitable person available right now, so the government has to step in, and what I want to do is become that suitable person. So before I begin, to sign a power of attorney, you must be considered mentally capable. Okay? I think I'm mentally capable. To be considered mentally capable of giving a power of attorney for personal care, it must be clear that you understand the need to choose someone with genuine concern for your welfare, and that there may be need for a person to make personal care decisions for you. To be considered mentally capable of giving a power of attorney for property, it must be clear that you know about your assets, what you own, what they're worth. You are aware of your obligations to your dependents, and you understand the authority and power you are giving to the person holding the power of attorney. Okay, so I think I am mentally capable because, I understand what all these words mean. I understand the context of all of them. I understand what my assets are. If you tell me what my obligations to my dependents are, I will verify your claim, and if they're valid, I will, fulfill my obligation. If they're not, I will not. You understand the authority and the power you're given. Yes. So I think I'm mentally capable. Find out more, but who knows, right? When you're in the circus, anything is possible. So choosing your attorneys, your good judgment is key to choosing a trustworthy person for this important responsibility. So apparently I have to choose a person, which according to the Ontario Interpretations Act, a person is a corporation. So I don't know what that's going to mean, because I am trying to choose a alternative. Do I have to create a new person? Okay, we'll see. So the person you choose as your power of attorney for personal care, this is for personal care, we don't care. For power of attorney for property, a person must be at least 18 years old. Okay. Anyone given power of attorney must be considered mentally capable when they are appointed. Okay. Choosing your attorney for personal care. So I don't care about personal care. Choosing your attorney for property. Important. Be very careful signing a power of attorney for property, because unless you specify otherwise, the person you name can start making decisions immediately You may want to include a statement in your power of attorney that says the attorney can only make decisions if you become mentally incapable. If you choose to appoint this kind of attorney, I do not want that. I do not want to only make decisions on behalf of my person if my person is mentally incapable, whatever that even means. If you choose to appoint this kind of attorney, make sure the person you choose understands your wishes and agrees to this important responsibility, which includes keeping detailed records of all transactions involving your money and assets. One option is to use a trust company to act as your attorney. A trust company charges a fee, but will be professional and impartial. So that might be an option. To set up a trust company to act as my attorney. You can create a power of attorney yourself using a free kit provided to you by the government. Well, thank you, government. The trillions of dollars spent, and what do we get? A 24-page document. All right. Cool. Let me see if anybody can hear me. If anybody's here. Anybody there? Nope. Is that the right one? Well, hopefully somebody comes. How long has this been going? Okay, so we got this down. We got this kit that we'll go through and read. And we can get a printed copy because is it probably free too, right? To use this kit, read it carefully and follow the instructions. Another option is to have a lawyer write your power of attorney. Consider seeing a lawyer if your personal or business affairs are complicated. Note that each power of attorney must be signed by you and 2 eligible witnesses. Some people are not allowed to be witnesses, including your spouse and your children. Always store legal documents in a safe place. Make sure that your attorney, your bank, and anyone who needs to know about these documents has a copy or knows where to get one. The government does not keep a registry of power of attorneys. So I just have to display my power of attorney. Is that right? Okay. So you may want to include an advance directive as part of your power of attorney for personal care. Now, personal care is the one we don't care about, right? Medical care, we don't care about that. Under Ontario law or statute. If you express wishes about your future care while you are mentally capable, these instructions will be binding on your attorney or other substitute decision maker, unless your wishes are impossible to follow at the time the attorney is asked to make the medical or care decisions. All right, so let's go through and read this kit that the government has graciously given to us. Powers of attorney. This booklet contains forms for continuing power of attorney for property and power of attorney for personal care, provided to us by the Ministry of Attorney General, not for sale. Ce document, given that I am in Le Belle Provence, but I cannot read Le Français. Okay, so we are only interested today in power of attorney for property. Okay, so I will skip the power of attorney for personal care, so it will only be a 8-page read. Okay, so Ontario's power of attorney laws. This booklet contains information and forms for a continuing power of attorney for property and a power of attorney for personal care. By making powers of attorney, people can plan ahead and be confident that their plans will be carried out. The role of government is to act as a substitute decision maker or of last resort only for people who have no one else to make decisions on their behalf. If there is no power of attorney, a family member or friend may have to apply to be appointed as guardian. Powers of attorney which are properly made under provisions of law of Ontario remain legally valid. The forms for a continuing power of attorney for property and a power of attorney for personal care contained in this booklet were revised on March 29, 1996, in accordance with amendments to the Substitute Decision Act 1992. I don't think I'll read that because who the fuck cares? Former revisions of these forms may be used and will be valid if properly completed and witnessed. If you have questions after reading these instructions, you may wish to seek advice from a legal professional. Of course. Some important definitions. This list of definitions will help you understand some of the unfamiliar legal or technical terms. An assessor. Assessors are persons who are authorized to conduct an assessment of a person's mental capacity for certain purposes, such as appointing a guardian for property without going through the court process. They have appropriate professional backgrounds and have successfully completed a training course in capacity assessment. They are independent of the government, but are they really independent of the government? Because who pays their salary? That's my question. Continuing power of attorney for property. So this is what we need. A continuing power of attorney for property is a legal document in which a person gives someone else the authority to make decisions about their finances. The person is named as the attorney does not have to be a lawyer. The power of attorney is called continuing because it can be used after the person who gave it is no longer mentally capable to make the financial decisions themselves. Some people use the word durable, which means the same as continuing. So this is what we need. So let's copy and paste this. Continuing power of attorney for property. So what is a guardian of property? A guardian of property is someone who is appointed by the public guardian and trustee, that organization, that who knows what that is, or the court, to look after an incapable person's property. Both the guardian and the incapable person must be at least 18 years old. A guardian is different from an attorney. An attorney is chosen by the individual before becoming incapable to act on their behalf, while a guardian is appointed after incapacity. The guardian can be a statutory guardian or a guardian appointed by the court. A guardian of a person, as opposed to a guardian of property. A court may appoint a guardian of the person to make decisions on behalf of an incapable person in some or all areas of personal care, unless because there is no power of attorney for personal care. Or usually because there is no power of attorney for personal care. But we don't care about personal care. Incapacity. Under the Substitute Decisions Act 1992, incapacity refers to mental incapacity. It means that the person is unable to understand information that is relevant to making a decision or is unable to appreciate the reasonably foreseeable consequences of a decision or a lack of decision. Okay, I wonder who's going to determine incapacity. Partners. Partners are two people who have lived together for at least 1 year and who have a close relationship which is of primary importance in both their lives and are considered to be partners. Personal care. Personal care includes health care, nutrition, shelter, clothing, hygiene, and safety. Power of attorney for personal care. We don't care about property management. The Substitute Decisions Act 1992 refers to decisions about property management and powers of attorney for property. So let's maybe make a note of this. Okay. Refers to decisions about property management and powers of attorney for property. Property means finances, which include any type of financial decisions or transactions that a person would make in the course of managing his or her income, spending, assets, and debts. For example, it could include budgeting expenses and paying bills, doing tax returns, safeguarding valuables, selling real estate, and making loans. So it does seem like somebody is claiming this power over my property, right? The public guardian and trustee. The public guardian and trustee's role is to act as a substitute decision maker of last resort on behalf of those mentally incapable people who have no one willing to act on their behalf. A statutory guardian. A statutory guardian is a person who is appointed to act on another's behalf without going to court. Statutory guardianship applies only to property or finances. There is no statutory guardianship for personal care. A statutory guardian can be a public guardian and trustee or someone approved by the public guardian and trustee to replace the public guardian and trustee as statutory guardian. So, again, maybe they have a statutory guardian over us. Who the fuck knows? Okay. Continuing power of attorney for property. This is what we want. This booklet contains step-by-step instructions for completing the enclosed continuing power of attorney for property form, made in accordance with the Substitute Decisions Act 1992. Decisions about property. If you become mentally incapable, who will pay your bills and your taxes? Who will look after your bank accounts? Who will manage your real estate and investments? The person you choose as quote-unquote attorney for property will take care of these things for you. The word attorney does not mean lawyer. The attorney can be a relative, a friend, or someone else. So the word attorney means to turn your allegiance towards. So the person, when you hire an attorney in the court, they turn their allegiance to you and represent you, the person, to the court. So anyways, that's a sidetrack. You may use the form contained in this booklet to appoint a person of your choice to make decisions about your property and manage your finances on your behalf. This may include doing things such as signing documents for you, paying your bills, or selling your home. This power of attorney will allow the person you appoint to manage your financial affairs even if you become mentally incapable. The person you appoint is called your attorney for property. You may name more than one attorney if you wish. If you have already made a power of attorney for property that continues to be effective after you become mentally incapable, you do not need to make a new one. If you wish, you may use another form or make your own, but if you do this, make sure that it meets the legal requirements necessary under the Substitute Decisions Act 1992 to make a valid continuing power of attorney. Okay, so this act tells us how to make a valid power of attorney. All right, maybe we have to look at that at some point. It's important to know that you are not required to appoint an attorney for property. This is your choice. Giving a power of attorney to someone is a very serious matter. You are given the person you appoint significant power over your property. There is always a risk that your attorney could misuse this power. If you have any doubts about the motives or abilities of the person you are considering, or are under any pressure from your proposed attorney to pick him or her, do not appoint that person. Before you decide, you may want to talk with your family or close friends. Although you are not required to consult a lawyer in order to make legally binding power of attorney, it is a good idea to do so. Consulting with other expert advisors is also a good idea, providing they are impartial and concerned only with your best interests. Yes, because your expert advisors and your lawyers are only concerned with your best interests. This document includes guidelines designed to help you complete this power of attorney. They do not cover every option available in the Substitute Decisions Act. Do they give us a quote? I mean a link? They do not. They are not legal advice. Some legal terminology in the statute has been described here in simpler words to make it easier to understand. The guideline also point out some of the reasons why you may or may not wish to make certain choices. But remember, all decisions are up to you. Refer to the enclosed continuing power of attorney for property form as you review the following instructions. Now, part 1, appointing your attorney. Read this section carefully before you begin to complete the power of attorney form. To make a valid power of attorney, you must be 18 years of age or more and quote-unquote mentally capable of giving a continuing power of attorney for property. This means that you know what property you have and its approximate value, are aware of your obligations to those people who depend on you financially, know what authority your attorney will have, know that your attorney must account for all the decisions he or she makes about your property, and know that if you are capable, you may cancel your power of attorney. Understand that unless your attorney manages the property prudently, its value may decline. Understand that there is always the possibility that your attorney could misuse the authority. Consider who you want to appoint as your attorney for property. You can choose anyone you want as your attorney, as long as he or she is 18 years of age or more. Many trust companies are prepared to act as attorneys and charge a fee for this service. Some individuals who choose this option because they want an attorney who is professional and impartial. Talk to the person you wish to appoint and make sure that he or she is willing to accept the responsibility involved in being your attorney for property. It is important to note that by making this power of attorney, you revoke any other continuing power of attorney for property that you have made before. If you have made such a power of attorney before and you don't want to revoke it, you should consult with a lawyer so that he or she will make the necessary changes to this form. If you want more than one person involved in your financial decisions, you can name more than one person to be your attorney for property, but you are not required to do so. On the other hand, you may decide not to name more than one attorney if you're concerned about the possibility of disagreement, or if you believe that it may be difficult for others to deal with more than one person concerning your finances. Please note that you cannot appoint the public guardian and trustee as your attorney for property unless the public guardian and trustee agrees in advance in writing to act as attorney for you. Okay. Once you have decided who you want to appoint as your attorney, write your name and the name of the person you are appointing in the space provided in Part 1 of the Power of Attorney form, which follows page 8 of these instructions. So let's find page 8. Here we go. Continuing power of attorney. Let's see if we can copy and paste. Not for sale. All right, let's see if we can do this. All right, so continuing power of attorney for property. Made in accordance with the Substitute Decisions Act, 1991. So how does this one look? 1. So I want my trust, right? Revoke, or my person, sorry. Acting as my person, revoke any previous continuing power of attorney. Print or type your full name here. for property made by me and appoint, I'm going to appoint myself, the man, to be my attorney for property. If you have named more than one attorney and you want them to have authority and to act separately, insert the words jointly and severally here. I do not want jointly and severally. I only want one attorney. This may be left blank. Leave it blank. If the person I have appointed or any one of them cannot or will not be my attorney because of refusal, resignation, death, mental incapacity, or removal by the court, I substitute. I want to substitute. I will substitute. If I become mentally incapacitated, I'll think about that. To act as my attorney for property with the same authority as the person he or she is replacing. I authorize my attorney for property to do on my behalf anything in respect of property that I can do if capable of managing property, except make a will, subject to the law and to any conditions or restrictions contained in this document. I confirm that he/she may do so even if I am mentally incapable. Conditions and restrictions. Attach, sign, and date additional pages if required. This part of the page may be left blank. Okay, and then what's next? Conditions and restrictions. I don't think so. Next, date of effectiveness. Let's do it as soon as possible. Not for sale. I can get rid of this. Date of effectiveness. Unless otherwise stated in this document, the continuing power of attorney will come into effect on the date it is signed and witnessed. Perfect. Beautiful. Compensation. Unless otherwise stated in this document, I authorize my attorney to take annual compensation for my property in accordance with the fee scale prescribed by the regulation for my compensation of attorney for property made pursuant to Section 690 of the Substitute Decisions Act. Cool. So I here have to witness, sign. Okay, so I will have to sign and witness this. So I will do this offline. If there's anyone out there who wants to be my witness, I'm not sure if anybody's watching yet. Cool. So, and then I have to get my witnesses' signatures. Note the following people cannot be witnesses, the attorney or blah, blah, blah. That's fine. Witness 1. We'll have their signature here. They will print their name there. They will have their addresses. Cool. And problem is I am in La Belle Provence and I don't know anybody here. Okay, anyways. Okay, so we have now the skeleton for a power of attorney. So let's go back and read the document just to see what we're talking about, although I think it's pretty self-evident. So step 1, appointing your attorney. Read the section carefully. We already read this, right? Yep, we did. So part 2, joint or separate attorneys. Fill out this part only if you have named more than one attorney. We've only named myself, and you want your attorney to be able to make decisions separately, that is, without having to act together, you can name more than one person as your attorney for property. If you do this, you may decide whether they will share the job or divide their responsibilities, or you can name one person as your attorney and another person as a substitute or backup who could step in if your first choice resigns, gets sick, or dies. If you have appointed more than one attorney in the form, the law will require them to make decisions together. Okay, so we did not name, and we only have one attorney. I do want to see if they define here jointly and severally is a legal term which means together and separately. If you don't do this, your attorneys will be required to make your financial decisions together at all times. So let's look again at what we wrote. If you have named more than one attorney and you want them to have the authority to act separately, insert the words jointly and severally. Like to sever, severely, I think. So if I put jointly and severally, then that means they can act together jointly or severely or separately. Okay. Substitute attorney, this part is optional. Okay, if it's optional, then I won't do it. It could happen that your appointed attorney may not be willing or able to act on your behalf when the time comes, or something may happen after your attorney has begun to make decisions on your behalf that prevent him from continuing to act for you. In either case, you could be left with no one to manage your financial affairs, so you may wish to consider naming a substitute attorney. So I do not want to name a substitute attorney if I don't have to right now. Authority of attorneys. This part of the form is very important. It tells your attorney and people who deal with him or her the types of financial decisions your attorney is allowed to make. So let's see at part 4. I authorize my attorney for property to do on my behalf anything in respect of property that I could do if capable of managing property, except make a will subject to the law and to any conditions or restrictions contained in this document. I confirm that he or she may do so even if I am mentally incapable. Okay, so I guess you can change this, but I don't think we want to change that, right? This part of the form gives the attorney the authority to make any kind of financial decisions that you could make yourself, except make a will. If you wish to limit your attorney's authority, you may do so later in part 5 of this form. So part 4 of the form also states that the power of attorney may be used even if you become mentally incapable of making financial decisions. It makes it clear that you want the power of attorney to continue to be effective if this happens. Part 5, restrictions and conditions. The law permits you to limit your attorney's authority. For example, you may limit your attorney to transactions concerning specific assets, such as your bank account, or prohibit him or her from dealing with a particular piece of property. But think carefully before you limit the scope of your attorney's authority. If you become incapable of making financial decisions and your attorney does not have full authority, it may be necessary for your attorney, a family member, friend, or public guardian and trustee to be appointed as your guardian in order to manage the balance of your property. In that case, a management plan must be filed and security may be required. Also, an unlimited continuing power of attorney allows the attorney to end the involvement of the public guardian and trust if the public guardian and trust is appointed as statutory guardian of property. Wow, so my suspicion is that the public guardian and trustee is appointed as public guardian, as statutory guardian of my property. So also, an unlimited power of attorney allows the attorney to end the involvement. So we should make a note of this too. Right, so we don't want anybody fucking involved in our property. Okay, so maybe we have to then get this thing signed and then inform the public guardian and trustee that they are no longer statutory guardian of my property. Okay, you can put other types of conditions and restrictions in your power of attorney if you wish. Some examples of such conditions and restrictions are requiring your attorney to consult with specific people before certain decisions are made, specifying the type of investments your attorney may or may not make, requiring your attorney to give priority to certain people in making loans or gifts on your behalf, and specifying how disagreements will be resolved if you have named more than one attorney, which I have not. These are just some of the examples of the types of conditions and restrictions you may want to think about. So I can also add something that's, no, I don't want to do that. But remember, you are not required to put anything in this section. Okay. Date of effectiveness, we said we're fine with the default. Compensate. Should we read it just in case? No, I don't think so. Compensation. Your attorney is entitled to take payment at a rate set out by the law unless you say otherwise. The amounts are the same as those allowed to guardians of property, effective April 1st, 2000. The rates permitted to guardians and attorneys of property are 3% on monies received and paid out, and 0.3% on the average annual value of the assets. If your attorney acted under your power of attorney before April 1st, the rates permitted were 2.5% on monies received and paid out, and 0.2% on the average annual value of assets. If there's more than one attorney, they will have to share. Okay, so we don't care about that. Your signature. Okay, we do care about this because I am in the Belle Provence. I am not in the property commonly called Ontario. So your signature, read each page of the form carefully before you sign it. Before you sign it, be sure that you understand the power of attorney will have you understand the power your attorney will have and when the document will become effective. You trust your attorney to act in your best interests. You are signing this document of your own free will and not because of pressure from anyone else. You have carefully considered obtaining advice from a lawyer or other trusted advisors. You must sign in front of 2 witnesses as described in Part 9. So we will read Part 9 in a second. If you are sure that the form says what you want it to say, sign your name in Part 8 of the form. After you have signed the form, print and type the date and your address in the appropriate space. Part 9, witness signature. The law requires that 2 people witness your signature. Both of the witnesses must be present together when you sign. Certain people are not allowed to sign as your witnesses. These people are listed in Part 9 of the form. After you have signed, the witnesses should each sign their names in Part 9 of the form in your presence and in the presence of each other. Additional guidelines. What to do if the person making documents cannot read. That's not me. I can read. What to do with this form after it is signed. You may wish to have it reviewed by an expert advisor. If it is not completed properly, it may not be valid. It is advisable to tell your family, lawyer, and financial institutions you deal with the name, address, and the phone number of your attorney. Keep them updated regarding any change in your attorney's address or telephone number. Please do not return this completed form to the public guardian and trustee's office. It is not necessary to register your continuing power of attorney for property anywhere. We recommend that after you complete this document, you take a copy to your bank so that they understand your wishes and have it on record. If this document is properly completed and you make it of your own free will and you are mentally capable, the bank must recognize it. They may have questions, and it is best to have those resolved before your attorney needs to use the document. You may give the original document to your attorney, leave it with a trusted person other than the attorney to hold it for safekeeping, or keep it in a safe place where the attorney can locate it quickly if necessary. It is a good idea to keep at least one photocopy of the document. If possible, keep it with you, with the address and telephone number of your attorney. Revoking this power of attorney. You have the right to revoke, cancel this power of attorney at any time as long as you are capable. If you decide to revoke this document, you must write the revocation on paper, sign it and date it, and have it witnessed in the same way. Okay, what about online witnessing? It doesn't talk about that. Okay, so I think, guys, we got the basic of it. I don't think there's much left to go over. I'm going to have to find a way to get 2 witnesses. Yeah, that's my next step. All right, so that was step 1, creating the power of attorney. I hope you guys learned something. I hope my logic for creating this made sense. So please leave some feedback. Let me know what you guys think, if this was useful, if there's anything else that, I'm missing or I can go over, please let me know. And thank you, and we will be back for step 2, which will be to read the 86-page document that I received from the applicant. So if that sounds interesting to you, then join me on my next stream. Thank you, guys. I am Lorenzo, and this is Lorenzo Family Law.